Hello, my name is Jane Jordan, and today we're about to witness the events of the landmark Supreme Court case, Gideon versus Wainwright. Today is June 3rd, 1961, at the Bay Harbor Pool Room in Panama City, Florida. As a longtime drifter who's been in and out of prison for his entire adult life, Gideon caught one glance at this unoccupied pool hall and hatched an idea. Well, that just happened. Gideon was then arrested, and as you'll soon come to see, will have a bit of trouble affording a lawyer. Here's Gideon preparing to represent himself in trial. With only an 8th grade education, he's going to have his work cut out for him. It's now August 1961, and we're here at the Bay County Courthouse in Florida, where Gideon is about to realize that he's not entitled to representation.
This is the day and time appointed for the trial of Mr. Gideon. Before we begin, counsel, for the record, what are the charges the state of Florida is bringing against Mr. Gideon?
Yes, Your Honor. The prosecution is charging Mr. Gideon with breaking and entering with the intent to commit a misdemeanor, which is a felony in the state of Florida. The state has evidence that Mr. Gideon smashed a window leading into the pool room and stole approximately 12 bottles of beer, 12 bottles of Coca-Cola, several bottles of wine, and about $5 from a cigarette machine and $60 from a jukebox. We also have eyewitnesses' testimony stating that Mr. Gideon was leaving the pool hall at the time of the crime. Thank you, Your Honor.
Thank you, counsel. Mr. Gideon, before we begin with proceedings, do you have anything you wish to address to the court?
Your Honor, I don't have a lawyer. Would I be able to get one from the state?
Mr. Gideon, I'm sorry, but I cannot appoint counsel to represent you in the case. Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense. Here, you're only charged with a felony. I'm sorry, but I will have to deny your request to appoint counsel to defend you in this case. You will have to proceed as best as you know how.
Well, the United States Supreme Court says I'm entitled to counsel.
Mr. Gideon was convicted by a jury and was sentenced to the maximum of 5 years in jail. Here's Mr. Gideon writing his petition for cert on a legal pad from prison. Let's hope this one goes a little bit better for him. It is now January 15, 1963, where petitioner Mr. Gideon and respondent Mr. Wainwright are about to give their oral arguments. What we're about to see could just be groundbreaking, as it just may incorporate the 6th Amendment right to counsel to the states.
Court is now in session. Oral arguments in the case of Gideon versus Wainwright will now commence. We'll begin with briefing from counsel as requested on the case of Betts versus Brady and whether the court should reconsider that case. Mr. Gideon, we'll start with your counsel.
Yes, Your Honor. Ready to proceed. Mr. Chief Justice, may it please the court. This case is here on writ of cert to the Supreme Court of the state of Florida. In issuing this writ of cert, the court expressly requested counsel to discuss the following question. Should the court holding in Betts v. Brady be overturned? The question, of course, is the right of the accused in state criminal proceedings to the appointment of counsel, specifically in the present case which you have before you. The question is exceedingly narrow one. Simply on practical grounds, Betts v. Brady should be overturned. It was not then and is not now solid law. As indicated in the case of Mr. Betts, when he was convicted by a bench trial and argued his case to the best of his ability. And in this case, Mr. Gideon argued his case to the best of his ability. It is soundly against the due process law afforded under the 14th Amendment to the respect of individuals untrained in the law to navigate the judicial structure of this nation. In Betts v. Brady, this court stated that they are not required to appoint a lawyer for a criminal defendant, provided that the trial is fundamentally fair. Take this case for example. My client over here has an 8th grade education, has been in and out of prison. How's he supposed to go against a knowledgeable professional trained in the field of law? It doesn't make sense, Your Honor. We ask that this court reverse the holding in Betts v. Brady and find that it is the right of the accused in state criminal proceedings to the appointment of counsel. Thank you, Your Honor.
Thank you, counsel. Counsel for respondent, we'll hear from you.
Mr. Chief Justice, may it please the members of the court, I am from the Attorney General's Office of Florida, representing the respondent. This honorable court set forth in Betts v. Brady that the right to counsel is not a fundamental or essential to a fair trial. That decision is one based upon sound logic and legal reasoning. To require the states to subsidize the defense of the accused would be an unbearable expense to the state. This violates federalism, and this would be an imposition of an inflexible rule in this area that would be an unwarranted intrusion into the historic rights of the state to determine their own rules of criminal procedure. I'll also point out that although the majority of states now do provide for automatic appointment in cases less than capital, the states that do that do so by court rule and by statute and not by constitutional construction. In our state, the judges in our state have discretion, and they can appoint counsel when exceptional circumstances.
Counsel, are there circumstances when this occurs?
Yes, Your Honor. In fact, there are some judges who appoint counsel in all cases, and generally that is in the more urban areas. In the rural areas where there are fewer lawyers, and especially fewer criminal lawyers available, the courts have many times not appointed counsel as they do often in urban areas.
Thank you, counsel.
The court is in recess. Now the justices confer.
Thank you, counsel, for your briefing. The court has made its decision. As noted in Betts v. Brady, Mr. Bett argued that the right to have the assistance of counsel for defense in all criminal prosecutions extends to indigent defendants in state court via the 14th Amendment. The Betts court responded that the 6th Amendment laid down no express role for the conduct of the states, and therefore it sought to determine whether the 6th Amendment expressed a role so fundamental and so essential to a fair trial that it should be made obligatory upon the states by the Due Process Clause of the 14th Amendment. Utilizing the relevant data on the subject afforded by constitutional and statutory provisions subsisting in the colonies and states prior to the inclusion of the Bill of Rights in the national constitution, as well as in the constitutional, legislative, and judicial history of the states to the present date, the court concluded that the appointment of counsel is not a fundamental right essential to a fair trial. That determination, however, was mistaken. There was, even at that time, ample precedent to determine that this right is fundamental and is equally protected against state invasion by the Due Process Clause of the 14th Amendment, as it is against federal invasion by the 6th Amendment. 10 years before Betts was decided, the court examined all of the historical data and unequivocally declared that the right to the aid of counsel is fundamental. We echo that today. In addition to such precedent as Powell v. Alabama, reason and reflection, as counsel for Mr. Gideon pointed out, require us to recognize that in our adversary system of criminal justice, any person hailed into court who's too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. Regardless of whether the right of one charged with a crime to counsel is deemed fundamental in other countries, it is in the United States of America a fundamental right applicable against the states with the same force as against the federal government. History, precedent, and simple logic dictate this. The judgment is therefore reversed and the case is remanded to the Supreme Court of Florida for further action not inconsistent with this opinion.
Clarence Gideon had a tremendous impact on our criminal justice system. In state courts in the largest counties in the United States, 3 in 4 defendants with either court-appointed or private counsel were convicted. In federal courts, 9 in 10 felony defendants with public or private attorneys were found guilty. In addition to its impact on state courts, Gideon opened a period of intense activity to ensure competent counsel for federal defendants. In 1964, a year after the Gideon ruling, Congress passed the Criminal Justice Act, which provides funding for court-appointed counsel in federal cases. Today, nearly 90% of federal defendants were aided by lawyers, investigators, and experts paid for under the Criminal Justice Act, which is great for ne'er-do-wells like me.
Going.
Hey, what are you doing?
So that just happened.
Charging Mr. Gideon with breaking and entering with the intent to commit a misdemeanor, which is a felony in the state of Florida. The state has evidence that Mr. Gideon smashed a window leading into the courtroom.
Mr. Gideon, I'm sorry, but I cannot appoint you counsel under the
There goes our whole project.
Sideways.
Oh. Ooh.
in with briefing from counsel as requested on the case of Betts versus Brady, state of Florida, not the state of Florida. Alright.
Mr. Chief Justice, may it please the court, the case is here on writ to the Supreme Court of the state of Florida in issuing the writ of cert.
It is weird.
It is.
The court is in recess. Now the justices confer.
I need a moment to get myself.
Here's Gideon preparing himself for trial. Oh, preparing to represent himself? Okay. This impact on our criminal justice system. In state courts in the largest counties, 3 in 4 I'm sorry.
Your Honor.